Hello, this is the Housing Law Podcast. I'm William Flack, and with me is Daniel Bacon.
Good morning.
And today we're going to be carrying on a conversation which we were having in our last podcast about the service of documents electronically, and that covers notices in housing cases and related documents, and we'll also touch on service of documents within court proceedings. And where we got to last time was we were just talking about a case in which I had served a notice to quit on someone by email, and they had sent an email back which replied to it and also had my original as part of the reply, so you could see that they got it, asking me not to send any more documents to them. And I'd said, well, that was good because it showed they got it. And that was where we got to. And Daniel, you've been looking into this a bit more since then.
I have, yes. There is a particular case, which was a county court judgment, which I've been having a look at in respect of service of documents by email. The case is Calthorpe and Wahad Ali in 2017. And if listeners are interested in having a little bit more of a look at that, there are details in our show notes and notes at the bottom underneath the screen. The case related not to the Housing Act, but to the Leasehold Reform Act, and it related to a notice served under that. So the precise details aren't really relevant for our purposes, but what is relevant is the decision that the judge came to. And that decision was that service of one of these notices can never be valid. It is statutorily unacceptable.
You mean never be valid if it's served in a particular way?
By email.
Oh, right.
Yeah, sorry. Service by email of these notices under this Act can never be valid. And the reason for the notice being served by email under the Leasehold Reform Act not being valid is that elsewhere in that Act, it referred to copies of notices being served, but in the particular statutory provision for this particular notice, it said the notice needs to be served. So elsewhere in the Act, copies of the notice can be served. In this provision, the notice must be served. So for that reason, and other connected reasons, the judge found that service of a notice under that particular provision of the Act can never be by email, regardless of whatever might be in the leasehold agreement or any other agreement between the parties. Now, if we then look at the Housing Act 1988 and consider what that might mean for Section 21 notices and Section 8 notices, it is slightly worrying, because the Housing Act 1988 elsewhere does refer to copies of notices. And I've gone through each provision of the Housing Act 1988 just to see where those points are. And it does refer to copies of notices at Section 8A, Section 84, and Schedule 6A in a couple of places. So there is reference to copies of notices. Section 8 and Section 21, under which notices of seeking possession are served, there is no reference to copies of notices. There is only reference to a notice. A notice must be served. So using exactly the same logic as the Calthorpe case, albeit relating to a different Act of Parliament, but applying the same logic to the Housing Act 1988, we can conclude, if we find Calthorpe to be persuasive, that service of a Section 8 notice or service of a Section 21 notice by email can never be a valid method of service. Now, Calthorpe is only a county court judgment, so at best it's persuasive, it's not binding. But we know from previous county court judgments, particularly when, I think particularly of the issues relating to service of gas safety certificates, judgments by His Honour Judge Luber, although those judgments weren't binding, they were found to be very persuasive in the other courts. So potentially this is a concerning case, and would mean that any service by email of a notice of seeking possession cannot be valid. So I just wanted to raise that point.
And we've got the case of Wang, which we talked about, which is not a housing case, but I think it's an industrial tribunal case, where the judge went to the other extreme from saying it must be the original notice, which I think is what Calthorpe's saying, which is worrying. They went to the other extreme and said that you could serve a notice by WhatsApp.
Yes. Yeah, so in Wang, which was Employment Tribunal appeal, they found that it can be by instant electronic messaging, attachment to email, attachment to text. Any of those methods can be used to serve a notice. So they went to the other extreme. The usual approach to service by email that I think is probably more sensible than Calthorpe is, if there's a provision in the tenancy agreement allowing for service by email, then you should proceed on that basis. But email service is always a slightly tricky and unusual state of affairs in respect of service of any documents, whether they be documents to which the CPR applies or documents to which the CPR doesn't apply, such as notices of seeking possession, or other documents such as how to rent guides.
So let's just clarify then, so I've got it straight in my mind, that if you're on the duty rota and you're looking at a particular claim in a notice, would you be looking at, in the absence of anything in the tenancy agreement saying you can serve in a particular way, would you say the default position, that it has to be served, but can it be served by post, or do you have to prove that it's come to the attention of the defendant or tenant?
Yeah, so the tenancy agreement is the starting point for service of notices of seeking possession, because they are notices to which CPR does not apply. So there's no automatic provision for deemed service of a notice of seeking possession. And what that means is the tenancy agreement has to incorporate some provision for deemed service if the landlord is to overcome a denial by the tenant that they received the notice. So I mentioned in the previous podcast that if the tenancy agreement incorporates section 196 of the Law of Property Act, then that allows for service to be deemed if it's been left at the last address, if it's been posted through the front door or sent by registered recorded delivery and not been returned. If those methods are used, then you can say that service has been deemed valid. The courts have also found that if section 196 is incorporated, then you also extend your incorporation to include section 7 of the Interpretation Act, which allows deemed service for any service by post. So I spoke a little more in detail about those points in the previous podcast. But one really interesting thing is that the deemed service provision of section 196 is slightly different to the deemed service provision of section 7. And in a recent case that I was looking at on behalf of the landlord, they had incorporated an express provision, not citing section 196 or section 7, but just basically repeating what the provision of section 7 is, just in plain language. So what that is if it's served by post, then it'll be deemed served within the ordinary course of when the post would be delivered. Now, if the tenant is able to prove that they didn't receive that notice, then the section 7, or any provision that's similarly worded to section 7, the section 7 provision is only a partial deemed service provision. And so the Calthorpe case, again, it's the same case as that dealt with service by email in the county courts, Calthorpe found that a bare denial by a tenant that they didn't receive a notice in accordance with Section 7, a bare denial isn't sufficient. They would have to have actual proof, such as they were out of the country or they were in hospital or something like that. But if the service has been done in accordance with Section 196, then that's a complete deemed service provision. So it doesn't matter whether or not the tenant can prove that they didn't receive it. If it's been served in accordance with Section 196, such as left at the last known place of abode, then it is deemed served, regardless of anything else.
So can I just check with you then, going back to the situation where you're on the duty rota and you're looking through the documents, and if you find that the tenancy agreement doesn't incorporate either of those statutory provisions and has no provision regarding service that's non-statutory, it's just silent on that, would you be saying that a possible defence is that there's no evidence that it's been brought to the attention of the tenant, and especially if the tenant says yes, I got it, which I suppose they are obliged to do if it's the truth. But if the tenant says I didn't get it and there's nothing in there to say that it's deemed in any way, you've got a defence to say, well, there's no proof of service.
Yeah, and so the defence would be that the notice hasn't been properly served.
Similarly, if you were acting for a landlord and you were asked to issue possession proceedings, you'd be checking the same things to avoid a car crash at the first hearing.
And if there's nothing in the tenancy agreement, then you better
get a personal service.
Yeah.
So I think that covers notices. That's notice of seeking possession, and the same thing presumably true of notices to quit, which occasionally arise in things like, actually, the notice I served was on a lodger, so it was a notice to quit rather than a statutory notice. But the other thing we were talking about was the documents which need to be provided in order for Section 21 notices to be valid, and which there seems to be a sort of increasing number of documents every year. But the most one of the most recent additions to the list of documents is the How to Rent leaflet, I think, which came in a while ago. And the effect of that is that if not only must the landlord show that they had given a copy of a copy of the How to Rent leaflet to the tenant before the notice of seeking possession was served, it has to be the correct edition of the notice. So if you served the if you served the 2018 edition in 2019, after the 2019 edition came out, it's not valid, which seems to be a minefield waiting for any unsuspecting landlord who wasn't advised by somebody who's really up to date on the law.
Yes, absolutely. And interestingly, on the email point, unless there is an express provision in the tenancy agreement or some other express agreement with the tenant that they will happily receive documents to a particular email address, the How to Rent guide cannot be served by email. That is written into the regulations. That's an independent legal fact, quite apart from the judgment in Calthorpe. So it is not possible, without any express agreement, to validly serve a How to Rent guide on a tenant by email. Which means if you try and do that, you're not in compliance with the regulation and you cannot serve a Section 21 notice, which is valid.
So a landlord at the beginning of a tenancy has really got to make sure that they physically give hard copies of documents to the tenant. And I think some of them have to be given before the actual tenancy agreement starts, don't they? So the gas safety certificate and the energy performance. Am I right or am I wrong that they just have to be served?
The energy performance has to be served at some point in the tenancy.
Okay.
So that should be at the beginning. But if there's a defect there, that can be corrected. The gas safety certificate Yeah, certainly there was a judgment that it needed to be provided before the start of the tenancy. I think that might have changed. So I think there's been a change. I think there's been an updated Court of Appeal case or even a Supreme Court case in relation to that. But I need to double check those points. So I don't think that's fatal flaw anymore.
But anyway, they'd have to be able to, I mean, ideally, if you're a landlord and you're going to court, you want to be able to produce a bundle of relevant documents of the kind we just mentioned that have to be given to the tenant. Ideally, copies which were countersigned by them confirming that they received them and the date they received them.
Yes.
Short of that, you're looking at difficulties, and the most serious of which would be if you just assumed that you could send them an email with all the stuff attached. At this point, could I just mention the case of Lescott v. Heil, which is a new case, 2022 case. It's not reported anywhere other than I found it on the Landmark Chambers website. And this is a really important case for emphasizing what we're talking about here, because anyone listening may think that these points are so trivial and petty and peripheral and technical that only sort of nerds would be interested in them. And that when you get to court, some sensible judge will say, "Oh, don't be silly. These points aren't central." But Lescott v. Heil shows just how serious the problems are. And in that case, the landlord got a possession order against somebody who was an assured short-hold tenant relying on a Section 21 notice. The tenant then appealed, saying that the how to rent leaflet which I was given was not the most up-to-date version of it, and therefore the notice of seeking possession was invalid. That appeal succeeded, and just to emphasize how strict the courts can be, during the course of the appeal, the landlord discovered that they had in fact served the right edition of the how to rent leaflet, but when they drew up the particulars of claim, they referred to the wrong one. So they asked the judge for permission to amend the particulars, or the appeal judge to let them amend the particulars of claim so that they could then rely on the notice. And the court refused that and said, no, they had to go all the way back and start again because it wasn't for the appeal court to let them clear up their mess, which shows that just because the wrong leaflet was served, the wrong edition of the leaflet was served, it wasn't just that a bad-tempered judge at an initial hearing did that. It was actually on appeal. It was a ground for appeal. So it really is a serious problem for landlords, and something that tenants advisors should be aware of as a powerful weapon. That all of these points we're talking about can make all of the difference.
Yeah, they can. And I mean, it's worth noting that that requirement for service of the how to rent guide in the correct manner as well is a regulatory requirement. So it's regulation 3 of the AST notices and prescribed requirements 2015. So it's written into legislation. And likewise, the issues in Calthorpe, admittedly relating to leasehold issues rather than Housing Act 1988 issues. But the issue in relation to service by email, potentially, is a statutory issue. It's an issue that's been raised because of detailed analysis of the way the law is written. So any breach of any requirement or any non-compliance with any requirement where those requirements are statutory or regulatory, those are going to be mandatory requirements. And Section 21 is mandatory. There's no defence other than a technical defence. Section 8 is slightly different. If the landlord is relying on the rent arrears grounds, which landlords usually are with Section 8, they'll probably be citing grounds 8, 10, and 11. Ground 8 is a mandatory ground, so complete technical compliance is required for ground 8. grounds 10 and 11 is slightly different. The court does have the discretion to dispense with service of the notice of seeking possession for grounds 10 and 11. So if there's been some issue in terms of compliance, if, for example, the notice of seeking possession has been served in a way that is non-compliant, so for example, if it's been served by email and the court takes the view that Calthorpe judgment is very persuasive, for example, then the court might say, well, this notice hasn't been validly served. However, I can exercise my discretion to dispense with service of the notice, and that corrects the defect, or at least it overlooks the defect, and the possession proceedings can then proceed on that basis. But it is still very valuable, because even if you're only excluding ground 8, which is the mandatory ground, that places your client, if your client is the tenant, in a far better position than if they're facing a mandatory ground 8 possession for rent arrears.
Because they can then start introducing other things such as reasonableness and, well, mainly reasonableness into the mix as to whether they've got a defence.
Absolutely.
So, and I would have thought that most judges, if they're in court and they can see that the defendant is there with a copy of the notice which they printed out, having received it, be inclined to say, well, I'm going to dispense with service because it's obvious you've got it. Whereas, having said that, where would that leave us with the ground with the Calthorpe principle? That if the judge sees the tenant with their printout of the notice and says, well, you've clearly got it, I can see it in front of you.
So if the notice cites grounds 8, 10 and 11, then the judge is going to be able to dispense with service for grounds 10 and 11. But the judge can't dispense with service.
Even if the judge can see the tenant with the document that the tenant says wasn't validly served on them, the judge has to say, no, that wasn't served. The document which I can see with you holding there wasn't served validly.
If Calthorpe is persuasive, and Calthorpe may not be persuasive, but if Calthorpe is persuasive, and if the same logic applies to the Housing Act 1988, which it can apply, because the same sort of...
You're right, because it would be fatal, wouldn't it? Because it would be all that the tenant would have in front of them would be a printout of a copy of the notice, which they're not allowed to serve, which does show the sort of completely pre-digital nature of Calthorpe, isn't it? It goes back to the old days.
But it's only a 2017 judgment. I mean, it's very recent. And I mean, that's the crazy thing about looking at statutory provisions in such detail. You can end up with some very weird and wonderful outcomes.
Yes, and you can never underestimate the extent to which judges can participate in that and make decisions which, as in Calthorpe, seem to beg a belief in the modern age. But nevertheless, from the judge's point of view, they're faced with a law. I mean, they're not there to play God. If the law says that, they have to stick with it, and it's for somebody higher up or in Parliament to change.
Absolutely, it's not. It's not. And if a judge thinks that's the correct approach and the correct logic to apply, then I think it's better that they do apply it in that way rather than take a sort of crusading approach.
Oh yeah.
Because these laws are written by Parliament. Regulations are written with the authority of Parliament, and it.
No, just for another thing. I mean, you need to have certainty in the law. You can't have just because you get a particular judge who has a strong view on a particular issue, you're going to get one decision. I mean, in reality, that does tend to happen, I find. But it's inevitable with human beings. But the extent to which it should be encouraged is obviously zero. Should we just move on to the issue of service of documents electronically once proceedings have started?
Yes.
Because what we've been talking about up until now is just pre-proceedings, and then we've got and as you said, the deeming provisions of the CPR aren't involved. But I don't think we need to go into too much detail about this, because the law on electronic documents actually is fairly straightforward in terms of service within proceedings, although the route to finding it is a little bit difficult. It's a practice direction which goes with a particular rule of the CPR. But the bottom line is that you can't serve documents electronically within proceedings without the agreement of the person receiving them. Yeah. And that has to be express agreement. It can't be that although I had a case which I've done a blog post on, which I'll put a link to in the show notes, where Lambeth Council tried to argue that because I regularly almost exclusively corresponded with them by email in relation to the proceedings, that was by default a sort of admission that I would accept any documents by email. But that was despite the fact that I'd written to them complaining about the format of the documents they'd sent in email. So when it went to court, the judge found that Lambeth weren't entitled to assume agreement, and I hadn't expressly given it, and therefore they hadn't served the documents. Mm-hmm. And the leading case on that is the case. It's a Supreme Court case from Barton v. Wright Hassel in 2018, which shows how serious this is, and it's a sort of nightmare scenario that every litigator fears, which is that on the day before a limitation period for issuing proceedings expired, the claimant served the particulars of claim. I think he'd already issued a sort of holding summons, but he had a deadline to serve the actual particulars of claim, and he did it by email the day before the deadline expired. And the solicitors who he served it on pointed out that they hadn't agreed to this, and therefore they were not treating it as good service, which meant his whole claim failed. He appealed this all the way up to the Supreme Court, where it was held that the solicitors were right and he was wrong, and that he had to get agreement. Now, in that case, actually, Lord, I've forgotten, it's in the show notes, one of the judges made a good point to say, and this is along the lines we were just saying about judges having to apply the law. The judge made the observation that the extent to which this is sort of a good idea and in the public interest may be questioned. So I mean, it was with regret, I think, that he had to deny this person access to justice. And I noticed that in February, the Law Society Gazette reported that the dispute, this sounds very nerdy, but the Dispute Resolution Committee of Birmingham Law Society had issued a petition calling for the rules regarding service of electronic documents to be changed and brought up to date so that email would be sufficient. And my view is that the only way you could really do that is by legislation of some sort, maybe not.
Well, I mean, the CPR only needs, so however they update CPR, and they update it regularly. So for the service of documents.
Oh, you're quite right. Yeah, they could amend the CPR, couldn't they, to say that electronic documents are fine?
Yes.
That's almost like a sort of semi-legislative, isn't it? It's a rule being changed. It's not going. There isn't going to be some case where a judge says, actually, the Supreme Court got it wrong, or the Supreme Court later finding that they made a mistake, which very rarely happens. But I mean, it would have to be a change in the rules, or
So a change in the rules to the CPR would correct, or at least would update the rules in respect of service of documents to which the CPR applies. But CPR does not apply to service of how to rent guides, and CPR does not apply to service of notices of seeking possession. So those issues would require statutory, in the case of notices of seeking possession, or regulatory updates in the case of the How to Rent Guide. So it'd be a little bit more work in respect of documents to which the CPR does not apply.
Yeah.
But be fairly straightforward, I think, in respect of CPR documents.
So I think that sort of completed our little tour of the issue of service of documents. So I think the concluding point you'd have to say is, obviously, working backwards, don't try and serve anything within proceedings without getting agreement electronically, because you may fall foul. And maybe people won't notice, actually. I mean, 80% of the time people are exchanging documents without saying, is it okay if I send this to you electronically? And it gets accepted. But that could be fatal. Then for the notices and documents point, I think the starting point is that unless you can show that you've personally served all of these documents on people, then the dangers increase from there, and it's safest to ensure that they are actually personally handed to them, and acknowledge and get receipt is acknowledged in writing, ideally. And if they haven't done that, then the defendant's advisors at court should always be looking for these points, which are sometimes overlooked. I mean, I think quite often, but people don't think. Well, they think if the client's got the notice or refers to it, or it's in the particulars of claim, then there's no dispute that there was a notice. But it's been very useful for me actually going over this again now, because I'd always found the issue of notice a little bit sort of something I was a bit too technical, and I'd come back to it another day. But now it's sort of, I feel that the knots are untied a bit, and I'm feeling more confident. I think what we could talk about another time is another sort of nerdy point, which is the precise date when notices need to be served, because there's lots of sort of cases where lawyers argue about the fact that the notice of seeking possession was served on a Monday when it should have been served on a Tuesday. Which makes it invalid. But we could enjoy that one maybe next time.
Yeah, absolutely.
So I think that's everything for today, isn't it? That we've covered. I think we'll try and do these every week or 2 weeks, and maybe try to cover one particular subject or other subjects. If people watching this on YouTube, I mean, it's going to be on YouTube, and also I'll put a link on my blog to the audio file for this. But you can leave comments on YouTube or on the blog. And if there's anything else you'd like us to talk about, or things you think we've got wrong here, or things we've missed, please let us know, because it'll be useful. And I should mention that, all comments are welcome, apart from things like get your ears pinned back, which is which I've had before. So please do participate, and we can improve the quality of this for the future. So I think that's it for now. Anything else you want to add, Daniel?
No, I think that's everything.
Okay, bye-bye.